Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you the Roadside Chat. And my question comes from an officer in Utah and basically says, does a driver's claim of injury, like to the knee, invalidate the SFSTs, right? And the answer is not necessarily. And the reason why the officer is bringing this up is because he's been to my classes and he remembers me talking about where you have facts and circumstances that build reasonable suspicion or build probable cause. Just because there's an innocent explanation to one of those facts does not necessarily mean that cops cannot use that fact or circumstance towards their reasonable suspicion and probable cause, right? So that idea comes from, Terry versus Ohio, right? Where Terry and two of his friends, a guy named Katz and another guy named Chilton, were going in front of a store, looking in the store multiple times, like 12 different combinations of times looking in the store. And Detective McFadden with the Cleveland Police Department knew something was up, right? But in and of itself, was that a crime? Well, no, right? That could be aggressive window shopping. Or here's the innocent explanation. It could be that they're waiting for their girlfriends to get off work to go to the movies. But was it still suspicious? And the answer is yes. And that can contribute to probable cause. Another way of looking at this is called the divide and conquer technique used by defense attorneys. The attorney will say, isn't it true, officer, that what you observed and you thought was suspicious could also be innocent behavior because of X, Y, Z? And what they do is they try to divide and conquer. They divide all the facts and they try to pick apart, what you thought was suspicious, and then say, see, all that stuff is not suspicious because there's innocent explanations. Therefore, you're only left with these few things, and that's not enough for probable cause and so forth. So that's the basis of the question. That's why the officer is saying. So some further background in the question. So if a person says that they have a 10-year-old knee injury, and that could explain why they're doing so poorly on the standard field sobriety test, can we even use that test? Does it basically invalidate the test? And the answer is not necessarily. So the first thing you got to know is that we base these facts off of the totality of the circumstances. Is that something that courts want you to consider? If the driver says, I have a knee injury, 10 years old last week, should you consider that? Absolutely. Absolutely. But if the guy's saying, yeah, I have an old football injury, and he still looks like he's, ambulatory, right? He's walking and so forth. You say to him, well, look, I would like you to perform these tests. If I will consider the fact that you have an injury under the totality of circumstances, but I would still like to see your performance and review it, right? Maybe you're looking at the injury and you're like, okay, clearly this guy cannot do the one leg stand on that knee. Well, let him know. Do you want to use your other leg to stand on? But the point is just because that fact may go in favor of the driver does not mean that the test is completely invalid. But you be prepared to talk about that in court. Say, yes, it is true that bad knee could affect his walk and turn. However, there were other things that he also did, like using his arms. He still used his arms for balance. He missed heel and toe on both feet. So maybe if he says that his left knee is the one with the injury, could he not perform with the other foot, at all, appropriately? The one leg stand, again, he used a leg that was non-injured. So also when he got out of the car, he came right to me. He seemed to walk just fine based on the totality of circumstances. And it's a great question. The fundamental legal principle here is that you should consider it, but look at the big picture. Does the big picture indicate that he's intoxicated, right? Don't forget the other signs of impairment, not just the walk and turn and the one leg stand. Obviously you have HGN, you have signs of intoxication, the odor of intoxicating beverages, and so forth. All right. So hopefully that helps. Keep the questions coming, and do me a favor, hit hit the like button, comment, subscribe, share with your friends. Until next time, my friends, stay safe and keep up that great job.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.